The 2012 election is less than 2 months away. We detail the 2 ballot initiatives in this week's Capitol Report. Hello, everybody, and welcome to this week's Capitol Report. I'm Julie Bartkey. After months of waiting, the state Supreme Court has made it clear that the 2 constitutional amendment proposals passed by the legislature will be on the November ballot with the titles the legislature approved. Those amendments are voter photo ID and the marriage amendment. Debate surrounding the phrasing of the titles of each and the language on the ballot for voter ID made its way to the state Supreme Court, and the court stood by the legislature.
The best place to make sure there's an accurate ballot title is by it being forged by the consensus in the legislature. With the marriage amendment, this was a bipartisan effort, not the vote on it, but the agreement as to what the title was, that it was proposed by Senator Dibble of Minneapolis and accepted by Senator Limmer as a friendly amendment. And that is a much better way to form ballot titles than to have the Secretary of State unilaterally intervening and imposing what he thinks is a better title on this. The constitutional balance, it shows that there should be deference to the legislature. That's what the state Supreme Court said, and I think they got the constitutional balance right.
The reason why I say this is a big day for the people of Minnesota is that the Supreme Court correctly recognized the constitutional authority of the legislature. The legislature is the representational branch that represents the voice of the people, not the Secretary of State, not the executive branch. And this particular decision recognizes that close relationship between the legislature and the people of Minnesota.
These bills and their titles were fully vetted through the legislative process and approved by the Minnesota legislature. And they are now before the people of Minnesota. And the Supreme Court ruled, I think correctly, that they do in fact accurately describe what decision is being placed before voters.
Summer is now unofficially over, and the 2012 campaign season is well underway. Here to talk a little bit about the elections, we have Secretary of State Mark Ritchie. Thanks so much for joining us today.
Thank you for having me back on your show.
Mr. Secretary of State, there's so much going on, a lot of different tentacles out there concerning this year's election. I want to begin with the recent Supreme Court decision on changing the titles of 2 constitutional amendments. Your statement after that decision was essentially to praise the High Court on its prompt decision and then to ask voters to really study the issues and the candidates. So first, I want to ask you what your immediate reaction was when their decision came down.
Well, there was a dispute between the legislature of 1981, which set the law that said the Secretary of State shall provide the titles for a constitutional amendment. That was affirming a 1919 law. So for the past 100 years, the legislature had one set of rules, and the current legislature didn't agree with those rules. So the Supreme Court said, we will affirm the current legislature's decision that they no longer want that law to be in place. And essentially the Supreme Court overthrew that law or changed that law. And they did it just in time because we have to prepare ballots, mail them out to our soldiers and others serving overseas, and they cannot be late, because if they get them too late, they can't send them back, and so they can't be part of the election. And so the fact that they got it done right on time was perfect for us, because we have a lot of work to do to make sure everybody who has the right to vote has the opportunity to vote.
Were you surprised at all by their decision?
Well, you know, it was a kind of a partisan matter. It has had a lot of partisan energy to it. I don't think I was very surprised how the court split on a partisan basis. But it didn't matter. The legislature having an argument with itself can only be settled at the level of the Supreme Court. That's the only place. So the law said the Secretary of State shall provide the titles for constitutional amendments. Passed in 1919, affirmed in 1981. If the current legislature disagreed with that legislature, that can only be settled at the level of the Minnesota Supreme Court. And my issue was making sure we got the decision on time, Because our job is getting the ballots out so everybody can vote, but especially people who are out fighting to defend democracy, making sure they have a right to vote and the opportunity to vote.
The second part of this is asking voters to really study the issues. Are you concerned at all that maybe
Yes,
that might
actually,
fall through the
the
cracks?
Supreme Court made 2 rulings. So one on titles was a tiny one. I don't know,
Then
20
there's the
pages.
voter ID language as well.
There was a 120-page ruling, which was much more important because early on in our state's history, we decided to print in every newspaper what's actually being proposed to go into the Constitution, along with this very important document that the Attorney General provides called the Statement of Purpose and Effect, summarizing what is this language intended to do and what will the effect be. Often it discussed the taxpayer costs, because taxpayers are really concerned about the high cost of things. So at some point in our history, we had that as our procedure, but we also decided to never print the actual language that was going into our state's highest law, our Constitution, on the ballot. So until the early part of I think the 1970s, 1980s, everyone could read what was proposed to go into the Constitution and make their own decisions about that. At some point, because of budget and a lot of other considerations, we stopped printing what's being proposed to go into the ballot. And then it became a lot more politicized what was going to go onto the ballot, because it was clear that you could decide to correctly or incorrectly describe. You could decide to completely or in a very limited way describe. And so in a number of states, this has been a subject of great controversy. Courts have ruled that it's not okay to be inaccurate or unfair. The Missouri court, for example, on a very similar set of cases. So the citizens of the state, represented by a number of organizations, raised questions about the accuracy and the completeness or the comprehensiveness of the proposed ballot statement. The legislature said out loud, we think it's fine. The Supreme Court ruled, and with some very, very strong dissents, but they ruled that the legislature can put basically anything they want to on it, but not the actual language being proposed to go into the Constitution. And so we believe that it's important for the citizens to know what they're voting on, and we no longer put this in the newspapers like we used to. And so the only thing that's left is for citizens to take it upon themselves, and for the media, out of their civic duty, their civic responsibility, to resume that role that they used to have. I mean, I think it would be a very good idea to return to making sure that every citizen had the chance to read in the newspaper. But today, we have websites.
And it
we
is
have
on your
different
website,
opportunity.
correct?
Well, and it's also on a number of newspapers' websites. We are trying to urge people to go look the legislature itself. It's very interesting what the legislature has on its website as its overview and summary of the proposed constitutional elections is quite good and quite complete and very comprehensive. And so looking at the actual language, looking at how the legislature summarized it, can help voters understand. Because the main thing is that we, in the past, always limited constitutional amendments to one very distinct item. Now they have many. For example, this constitutional amendment on elections converts election day registration over to a new system called provisional ballots. So that affects about 540,000 people who no longer will be able to register and vote right there on election day in the polling place. They'll have to submit provisional ballots. It affects about 250,000 military voters and township voters who will have to change their system, and then it affects others as well. So summarizing a great big complete proposed amendment to the Constitution needs the kind of time and attention that citizens will have to devote so that they know what are all the ramifications. There have been no real serious attempts to publicize the cost, but also the costs are very important because they tend to fall right on those local taxpayers in the townships and towns. So my urging is for the media to put up the actual language and whatever information is available, and then for the citizens to make sure they read the actual language. Because once something's in a constitution, it's not something that the legislature can fix or tweet or correct a mistake, or some governor could fix. No. Even if the governor and legislature agree something is horribly wrong or needs to be fixed, you can't change the Constitution without going back through the constitutional amendment process to the citizens. So what you put in the Constitution is kind of forever until you go through the process.
And to that point, my last question for you concerning the amendments would be, some members of both parties have said that perhaps there needs to be a supermajority vote to get a constitutional amendment to the voters. What do you think of this idea?
Well, I know how we got the current unusual system of this very low bar. When Democrats and Republicans came together 152 years ago to write a constitution, they got into a big fight. They split into two. The Democratic Party wanted to take away the right to vote of freed African American men. So the Republican Party wanted to affirm the right to vote of freed African American men. They battled. They couldn't agree. The Republicans agreed to go along with the Democrats to take away the right to vote to freed African American men, but they got as their concession a very, very low bar for amending the Constitution, and then spent 10 years to restore the right of freed African American men to vote. So from the founding of the state, we've had this extremely low bar, unusual in the country. And most states have said, you got to pass it through 2 legislative sessions, you got to have a supermajority before it happens. At the federal level, it's 2/3 of the Congress, and I think 3/4 of the states. So I do think we have a very unusual story, which you can understand from a historical perspective, but I do think that the legislators who year after year propose a higher standard are thinking more like the other states across the nation. And I think the legislature probably will take some kind of look at this. And of course, that would take a change in the Constitution as well.
Okay, Mr. Secretary of State, thank you for joining us today.
Thank you so much.
When Minnesota voters head to the polls in November, they will have 2 different constitutional amendments to vote on. One of those is the so-called marriage amendment. We have the Senate author of that amendment, Senator Warren Limmer, here to talk a little bit about it and why you believe Minnesotans should vote in favor of this. Thanks for joining us, Senator.
Oh, you're welcome. I'm always glad to be here.
Always happy to have you. So again, chance for you to talk about this marriage amendment and the specific language.
A lot of people don't know why we're here. Why do we have this question before the public? And I think that's important to realize. A few years ago, there was a couple who wanted to be married in Hennepin County. They were a gay couple, and they were denied due to the Minnesota state law recognizing marriages only between one man and one woman. They immediately challenged the rule. That case is before the appellate court in the state of Minnesota. A number of other states have gone through this very same dance, and the courts have ended up defining marriage. And that's really not the role of the courts. They should be not writing law, they should be only interpreting law. And as a result, we thought in the legislature that it's time now that the public should be involved in defining marriage with their value system, not relying on a small group of politicians down in St. Paul, or even a smaller group of individuals, the judges, defining marriage from the bench. That's why the bill is now before the people of Minnesota this coming November.
Why do you think voters should vote yes on this amendment?
Well, first, it defines marriage as one man, one woman. It's the traditional definition that's lasted the test of time for thousands of years. Gay relationships, especially pushing into the marriage definition, is something that's more of a contemporary issue. Every time other societies have gone down the role of recognizing gay homosexual relationships, it seems like that society doesn't last long. That's a historical fact. But at the same time, when we look at the reason why anyone gets married, certainly you have the love interest, you have the relational bond, but it's also for propagation of the population. It brings order to that, and I believe that every every scientific study has shown that the best relationship for a child to be raised in is one that you have the balanced parental relationship between a father and a mother, and that's the ideal.
Senator, this bill has been described, or this amendment has really been described by many as the anti-gay amendment. Do you think this is an unfair description?
Well, I think that's a harsh description. We don't wish to have any negative connotation given to it. I believe it's a fairly written bill. It's simply the question before the public is, shall Minnesota's Constitution be amended to recognize marriage as solely between one man and one woman? Yes or no? And it's an opportunity for the public now to get engaged, have their year-long discussion. We kind of described it as, let's have a conversation. Let's talk about this, and let the public give the legislature a direction on how we should decide this. And I think now's the time to do that.
You spoke a little bit earlier about the fact that same-sex marriage is currently illegal in Minnesota. Mm-hmm. And you've also spoken about the intentions of this constitutional amendment. Did you think when you attached your name to it that it would be such a divisive issue as well?
Well, yeah, it's divisive wherever it goes. 31 states have considered it on their ballots. 31 states have passed it. I think it is important to have the public discussion. It's important to have the public involved. There's very few issues I would not give to the public in consideration, but due to time and the consideration of cost, we limit it to just very important issues that come up from time to time. But yeah, we knew it was probably going to be controversial. It raises a lot of emotional ire on both sides, and yet we shouldn't be afraid of controversy. We should be able to discuss this in a civil manner, have our public discussion, and then let the public give us direction.
You brought up the word controversy. There's been some controversy and, of course, the subsequent ruling by the state Supreme Court affirming that the legislature will provide titles for constitutional amendments. And the question's been asked about passing new legislation that might require a supermajority in the future to help pass any constitutional amendment legislation. I asked you about this at a news conference, and you contend that really the majority vote that matters is that of the voters in November. But aside from that, how do you feel about requiring a supermajority to move any constitutional amendment language out of the legislature?
Out of the legislature? Mm-hmm. I think it's fine the way it is right now. And the reason I say that is it gives the legislature a little wider berth to pass something, to give it to the public. We shouldn't be restricting the public on any question, and I think a supermajority requirement would. And as I mentioned to you earlier, once it gets to the ballot, it's not just a yes and no count on that particular question. They consider the whole universe total of people voting in the election, and you have to meet the 50% or the simple majority of the entire universe of people. So if you had 20% of the public, let's say they turned out for the presidential election, but 20% said, I don't want to vote at all for any referendum question, the proponents still have to meet the 50% plus one requirement of the entire population that happened to turn out to the polls. That is a high bar, and this is going to be as equally a high bar to pass this.
As voters head to the polls, do you think they should do some research on this, or is it pretty straightforward? And
I think they should. I think they should talk about it. I think they need to talk about it in their own communities. I think they need to talk about it in their faith communities as well. Get references from it. Give it plenty of thought. The one last position that I know would be definitely affected may be curriculums in public schools, reflecting now the newly recognized relationship of marriage of homosexual couples. We have health classes, we have sex education programs that are definitely referenced as heterosexual focus in those areas of education. Those could be challenged, and it could be forced education of a homosexual brand of health class being taught to our children as well.
Okay. Senator Limmer, thank you for your time and for your patience as you, and I'm sure our viewers can hear the light rail construction right outside of the window. Again, we appreciate it.
Progress waits for no man.
Minnesota voters go to the polls in November. They will vote on 2 ballot initiatives. We've already spoken about the marriage amendment. Now, Representative Mary Kiffmeyer is here to discuss voter photo ID. Thank you so much for joining us here at Capitol Report.
Glad to be with you.
So, Representative Kiffmeyer, let's begin with the definition of the photo voter ID amendment. The state Supreme Court recently ruled in favor of the language that was recommended by the legislature to be placed on the ballot. Can you kind of encapsulate for us just exactly what voters will be saying either yes or no to?
Well, they'll be saying yes or no, and by the way, if you leave it blank, that's the same as a no. That's the rules on voting on constitutional amendments. And so they'll be voting on the very simple process of saying, is a photo ID required as a part of the voting process? And also they will see that a free ID will be provided and that it takes effect July 1st, 2013 for that November election. But the essence of this constitutional amendment is the photo ID requirement.
You just mentioned the free ID provided, so I'd like to jump ahead to one of my questions. So if this does pass, how much responsibility do you believe the state does have in ensuring that those who might have a difficult time obtaining this ID, like a college kid or somebody who's elderly, how much of the onus is on the state to make sure that it's done efficiently and with relative ease?
Well, I think first of all, the state is responsible then to provide that state ID, okay? And I think no matter young, old, no matter whatever that kind of situation it is, to work with them. But you have 134 state reps, 67 senators, you have the governor's office, Secretary of State's office, and in other states, the Secretary of State office is very engaged with AARP, Lutheran, Catholic, atheist, I mean, you name it, everybody, as far as getting the word out and doing voter education to make sure that everybody knows, first of all, that they need to have one. We currently have a list that the Secretary of State office has matched with the Department of Public Safety. So they have a list of people who are registered to vote but do not yet have an ID. The good news is we know their name, we know their address. We can mail them and work with them and contact them to make sure that they know. So there is so much that can be done to reach out to everybody, and in the typical Minnesota way, using all of our connections and all of our groups to be able to reach out to them.
2 justices, as I mentioned earlier in this interview, the Supreme Court ruled on the language. Now, 2 justices dissented from that decision, and Justice Alan Page wrote in his dissent, I would conclude that the ballot question on the voting amendment proposed by the legislature is materially and fundamentally deceptive and misleading. Now, it's fair to say that you're going to disagree with this assessment.
Yes, I do disagree.
So it does beg the question, though, why not put the language from the legislation directly on the ballot?
Well, you know, the thing is you have precedent in the legislative processes. And so in all its years since Minnesota has done constitutional amendments and in all the recent history, the process has been that you put a title on, you do the ballot question, and you don't put the complete actual amendment changes on the actual ballot itself. That's not done. And so as a legislator, I would maybe agree that it would be good. I think it's just as Paul Anderson said, put it all on. I would agree. But that is not what the precedent was or the custom was. And so I followed that. And so the last 2 constitutional amendments back in the early 2000s were done in the same way. And that's why.
Okay, and also, as we're talking a little bit about some criticisms, critics also argue that if passed, this would disenfranchise certain segments of the population. Again, safe to say that you would disagree.
I would disagree with that. As a
assumption.
matter of fact, it will actually enfranchise them. It will actually make them more included.
How so?
Well, because when you're reaching out to give somebody a free state ID, that means you're giving them a free state ID, not only for voting purposes, but to open up a bank account, to do other things that are so common and so necessary that you have that ID. When they don't have that, it makes them vulnerable and dependent. And Andrew Young, former African-American mayor of Atlanta, Georgia, and then later an ambassador under, I believe, President Bill Clinton, supports photo ID. In part for that reason. It enables them to stand alone in the voting process, to have the dignity that goes with that. Plus, it's a valuable tool to be used in other facets of our society. And so I think it's an inclusive and franchising tool. And the big thing is to work with them and get out the word. Many of them, though, are on welfare benefits. So we can use that channel to communicate with them. Did you know you're going to be able to get a free state ID and help them to do that? This is so can-do and is an an inclusive and an enfranchising process rather than a disenfranchising. And in other states that have implemented photo ID, not one single case of disenfranchisement, not one in any of those states.
So ultimately, what's the intention of this piece of legislation, of this amendment?
Increasing public confidence, which thereby will increase voter participation. Because if you don't have confidence, you don't participate. And so that focus is really, really important. And I think that's why the public supports photo ID so much, because they stand in line to vote. They have those questions and concerns. They go through everything else in life where they're required to show an ID. The most valuable public thing you can have is a ballot. People are elected from it who spend trillions of dollars. And so in the public realm, who you vote for is a secret, who you are and where you live is not. It's a public list. It's a voter registration list. And so I think for all of us in realizing that the reason why there's that great public support for that is they have those questions. It'll increase public confidence. And the other thing is, right now, Minnesota's system is a catch 'em and prosecute. Meantime, the ballot is cast and counted. But we spend a lot of money and a lot of time afterwards catching and prosecuting. Right now, Minnesota's number one, 174 convictions, another 66 waiting, and that's just from the 2008 election. It's taking 4 years, court time, prosecuting time. Meantime, their ballot can't be pulled out. It's still in there. There are 6,224 people who cast a ballot, still not able to be found. Don't know where they are. They've checked the list, they've checked all kinds of places for them. They're still there hanging in the wind. In the meantime, those ballots are counted and included in the vote total from that election. So I think those people who stand in line have those concerns and questions. That's why they support the requirement of photo ID.
Representative Mary Kiffmeyer, thanks for coming in and advocating for the voter photo ID. We certainly appreciate your time.
Thank you for having me.
It's now easier to stay in touch with activity at the state capitol. Senate Media Services is on Facebook, YouTube, and Twitter. Find the links on our homepage. So follow us and follow the Senate. Each week on Capitol Report, we intend to educate and inform our viewers about both sides of key issues. This week, we were unable to get key lawmakers who oppose the constitutional amendments because of the Democratic National Convention and scheduling conflicts. However, we do intend to have those lawmakers on next week's program. And also next week, we will continue our discussion with the Secretary of State, focusing on the election, as well as talk about election trends with Professor Larry Jacobs from the Humphrey Institute. So that does conclude this week's program. From all of us at Senate Media Services, I'm Julie Bartkey. Thank you for watching.